and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we apprise you with the recent important legal developments across the country. Here are the headlines. Supreme Court to hear on May 26th, bail plea of AAP leader Satyendar Jain in the money laundering case. No EWS reservation in Jamia Millia Islamia for being a minority institution, claims the institution while opposing PIL in Delhi High Court. PIL in Delhi High Court against exchange of 2000 rupees banknote without identity proof. Delhi High Court directs medical examination of woman weightlifter rejected by CRPF for tattoo on forearm. Why CLAT cannot be held in Hindi? Delhi High Court asks NLUs. Now let's take a detailed look on the headlines. The vacation bench of the Supreme Court, comprising Justices A.S. Bopanna and Hema Kohli, will be hearing on May 26th the plea of Aam Aadmi Party leader and former cabinet minister in Delhi, Satyendar Jain, challenging the order of the Delhi High Court that denied him bail in the money laundering case. Jain is accused of money laundering by concealing the proceeds of crime by laundering the funds by way of moving them to 3 companies, and the matter is being investigated by the CBI and Enforcement Directorate, in whose custody he is since May 30th, 2022. His co-accused in the case, Vaibhav Jain and Ankush Jain, are also in custody and not granted bail. Jamia Millia Islamia opposed a public interest litigation filed in the High Court of Delhi, seeking the benefit of the 10% reservation for economically weaker section. The institution claims that the provision of such reservation is inapplicable on it, for it being a minority institution. In an affidavit filed by JMI, it was stated that the Government of India issued a memorandum dated January 17, 2019, that EWS reservation be provided in central education institutions, but the same is not applicable to minority educational institutions, referred to in Clause 1 of Article 30 of the Constitution of India. A public interest litigation has been filed in the Delhi High Court against the permission granted for exchange of Rs 2000 banknotes without an identity proof and without obtaining a requisition slip. The plea filed by Advocate Ashwini Kumar Upadhyay contended the move being in violation of Article 14 of the Constitution and the notification by the Reserve Bank of India, in this regard arbitrary and irrational. On May 19th, the RBI announced the withdrawal of Rs 2000 notes from circulation and said the notes can be submitted in banks and exchanged for smaller currency notes until September 30th. In order to ensure operational convenience, a communication was also made by the State Bank of India, informing all its banks that a requisition slip was not required to exchange the said currency notes. The same has been challenged in the present PIL, claiming that cash transactions in high value are the main source of corruption and used for illegal activities like terrorism, Naxalism, money laundering, etc. And so the RBI and SBI must make sure the deposit of money is done to bank accounts only to prevent the black money from being laundered. The High Court reserved its decision in the matter today. A bench of Justices Suresh Kumar Kait and Mini Pushkarna of the Delhi High Court directed the authorities to reconduct the medical examination of a woman athlete declared unfit for the post of head constable for having a tattoo on forearm and hand. The petitioner, who was already a constable in the Central Reserve Police Force, recruited under the sports quota in the 59 kg weightlifting category, claims that she participated in the recruitment process for the post of head constable, but was declared unfit for having a tattoo. She claims to have the tattoo removed now and to be examined by a newly constituted medical board within 4 weeks and to be allowed to join the selection process in the future. The Delhi High Court asked the CLAT consortium why the common law admission test cannot be held in Hindi when MBBS and IIT exams can be held in the said language. A division bench comprising the Chief Justice Satish Chandra Sharma and Justice Subramaniam Prasad posed the question to the counsel appearing on behalf of the NLUs, who said that a committee has been constituted to look into the matter. The case will now be considered on July 7th. Recently, the CJI D.Y. Chandrachud had said that cracking CLAT was an example of the barrier to access legal education and to enter the legal profession, as it can only be cracked by students having access to English medium education. That was all on today's legal news. Thank you and keep watching Verdictum and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.